Hello everyone, I am hoping you all are good and fine. So please let me know in the chat box, is right now I am audible or visible? So yes, I am hoping right now I am audible or visible. So today's session is again a very important session for your examination perspective, because today we are going to be cover one of the important discussion related to your SEBI Grade A Legal Stream 2025 examination. Of course, it's your 2026 examination right now. So today we are going to be cover a very important session related to your PYQ analysis. So what is the exact level of question asked in our sir 2022 and the 2023? So इस सेशन में हम पूरे डिटेल में देखने वाले हैं कि सर 22 और 23 में कौन कौन से क्वेश्चंस पूछे गए थे। आई होप कि आप सभी ने अभी तक 2024 के एग्जाम एनालिसिस को देख लिया होगा। अगर आपने नहीं देखा है तो इस सेशन के बाद उसको भी कवर कर लीजिएगा। 2024 की जितने भी पीवाईक्यू के क्वेश्चंस थे, टोटल 50 क्वेश्चन, एग्जैक्ट 50 क्वेश्चंस मैंने करवाए हुए हैं। डिस्क्रिप्शन में भी आपको लिंक मिल जाएगा और कमेंट बॉक्स में भी आप मांग सकते हो, मैं आपको लिंक पिन करके दे दूंगा। So now in this particular session, first of all we will discuss the 2022 paper number 2 in your phase 1 in 2022 examinations, all the 50 questions. तो जो भी 50 क्वेश्चंस आपके पूछे गए थे, जैसे आप सभी को पता है ये एक क्वेश्चन आपका कैरी करता है 2 मार्क्स का। सो वी विल कवर ऑल दोस क्वेश्चंस एंड ऑफ कोर्स आई विल नॉट ओनली कवर योर questions part, I will also be explain you the exact interpretation, the exact provision, how this particular question is based on, which particular concept is related to this particular questions. So each and everything we will going to be cover in this session. So yes, of course session is very important, so please like the session, as well as if you want to be share, you can be share with your colleagues and the friends. So those aspirants who are preparing for SEBI Grade A Legal Stream 2026 examination, so this session is very important and it become your eye-opener session that how the SEBI Grade A exactly asked this so many questions related to your paper number 2 and how you can be prepare yourself for the 2026 examination accordingly. So चलते start करते हैं आज के सेशन को। So जैसे कि आपको पता ही है, आज हम यहाँ पे करेंगे SEBI Grade A Legal Stream 2025 previous year recalled questions paper number 2 अंडर योर फेज नंबर 1। तो सेशन को फटाफट से लाइक कर दीजिए, शेयर कर दीजिए अपने फ्रेंड के साथ, चैनल को सब्सक्राइब करना ना भूलेगा, कमेंट सेक्शन में बताइएगा कि आपको सेशन कैसा लगा। बाकी डाउनलोड द एप्लीकेशन ऐप एंड Oliveboard application, and yes of course you will find the lots of PDF and more of the notes whatsoever you want, that will definitely will help you for the preparation of your SEBI grade examination. Apart from it, if you want to be connect with me, yes you have the Telegram channel access, just be you can be scan this barcode or else you can be search on a Telegram Chartered Ajay Thakral, I will be find you, and definitely you can be ask any of the question in this Telegram channels as well. Now we are starting the session, but before starting the session there is a one most important quote that we have. There is a no better way to exercise the imagination than the study of law. कहते हैं कि स्टडी ऑफ लॉ, अगर हम लॉ को पढ़ते हैं ना तो सच में अपने आप में एक इमेजिनेशन होता है, एक रियल लाइफ सिचुएशंस में हम चीज़ों को हैंडल करते हैं। और सेबी का ग्रेड ए का एग्जामिनेशन भी आपके इसी कॉन्सेप्ट पे बिल्डअप है कि आपके कॉन्सेप्चुअल अंडरस्टैंडिंग होना बहुत इंपॉर्टेंट है, तभी जाके आपका एग्जामिनेशन क्वालिफाई होगा। नाउ वी आर स्टार्टिंग द सेशन विद द फर्स्ट क्वेश्चन ऑफ द टुडे सेशन। सो पहला क्वेश्चन आप सभी की स्क्रीन पे ये रहा, एंड डेफिनेटली आई एम गिविंग यू द सफिशिएंट टाइम, so the first try to be solve these all the question by your own side, and once after the 1 minute I will exactly be tell you what is the concepts related to this particular question, and apart from it I will also be tell you what is the correct answer. So make sure whatsoever the time period I am giving you, whatsoever the stopwatch you are seeing on your screen, make sure you will complete your answer and put the correct answer in your comment box itself. सो आपका जो भी सही आंसर होगा प्लीज अपने कमेंट बॉक्स में बताइएगा, उसके बाद हम इसका करेक्ट आंसर देखेंगे। सो नाउ वी आर स्टार्टिंग विद द फर्स्ट क्वेश्चन, एंड द फर्स्ट क्वेश्चन ऑन योर स्क्रीन। सो आई एम गिविंग यू a 1 minute of the time. Please read the question carefully and let me know what is the correct answer of this question itself. Yes, guys. So this question is talking about right now, if the prescribed period of limitation for filing a suit, appeal or application expire on a day when the court is closed, such filing may validity be made. So this concept is related with your section 4 of Limitation Act 1963. So section 4 Limitation Act 1963 is talking about what, sir? Section 4 is talking about if any person who want to file any kind of suit applications, he must be filed within the period of limitations. And yes, at the time of filing the suit, let's say suppose if the court is closed, now you will get some kind of extension, the extension for the filing of your suit. Then in this particular scenario, you can file your suit when the court will exactly open in the next working day. So आपका जो टाइम पीरियड ऑफ लिमिटेशन है वो आपका एक्सटेंड हो जाएगा अगर जिस दिन आपका लिमिटेशन पीरियड एक्सपायर हो रहा है उस दिन आपका कोर्ट बंद हो तो. So this question is talking about when a suit, file or application expire on a day when the court is closed, such filing may be validity be made on the day when the court is reopened on the next working day fixed by the registry on any subsequent day with the court permission and within the 1 week after the court reopen only after obtaining the special leave of the court. So on the day when the court is reopen. So जब आपका court reopen होगा आप suit को file कर सकते हो but within the what? Within the normal working time. So that is always be keep in your mind. What is the correct answer? The option number A is the absolutely correct answer. Now we are moving forward to the question number 2. Now please read the question and let me know what is the correct answer of this particular question as well. So yes, this question number 2 is based upon your Limitation Act 1963. This question is talking about when the defendant is outside India. So in case when the defendant is outside India, so till the time period he remain outside India is totally be excluded at the time of computing the period of limitations. Outside India means what, sir? Outside India means you are outside to the border of India as well as from the central government territory. So if any of the defendant who is outside from the central government territory as well as through the territory of India, so basically you will actually the defendant, so in this case you remain outside India, so till that time period you remain outside India, no person, and yes of course no person cannot be file a suit against you, and definitely at the time of computing the period of limitation, the period you remain outside India is totally be excluded at the time of computation, the total period of limitation over here. So when I am talking about while the computing the period of limitation for any suit, the time during which defendant has been absent from the India and from the territory of the administration of central government, so what will be? It is totally be excluded from the computation of limitation period. So if you are selecting here option number C, yes of course your answer is absolutely be correct. Now we are moving forward to the next question. Please read the question very carefully and let me know what is the correct answer of this question as well. So yes guys, when I am talking about Article 1 of the Limitation Act 1963 is clearly be mentioning we have some of the prescribed period within which any of the aggrieved person can be take the legal action against the other person. So we have for a different suit we have some of the limitation period, And if you want to be take a legal action, you have to be file a suit, applications or appeal within such time period over here. So when I'm talking about any of the mortgage in which the suit for mortgager to recover the mortgage money by a mortgagee or otherwise charge upon the immoral property. So what is the time period we have? So in this particular situation, the mortgagee can file a suit within a what? Within a 12 years from the date of cause of action. And if you are not be filing your suit within this such time period prescribed under the Article 1 of the Limitation Act 1963, yes, after that it become your bar of that, and no court, no any legal judicial system will help you to against take your legal action. So this is the reason behind it. We have the correct answer is 12 year. 12 year from the day when the money become due. So within which time period you have to be file a suit in the court of law. And if you are not be filing the suit, yes, of course, no court of law will help you to recover your any of the money, because it become your time barred debt under the Limitation Act 1963. Now we are moving forward to the question number 4. Please read the question. This is based upon your Transfer of Property Act, and let me know what is the correct answer of this question as well. So yes guys, when I'm talking about the types of mortgage, you know very well, we have a different types of mortgage. Total we have the 6 type of mortgage. Yes na? So when I'm talking about the types of mortgage, total we have the 6 type of mortgage. And when I'm talking about the 6 types, so mortgage by conditional sale is one of the type under the 6 type of mortgage. What is the mortgage by conditional sale is talking about? Mortgage by conditional sale is talking about at the time of mortgage, the mortgager is transferring the property on the condition, and the condition is ostensible sale. Sir, what do you mean by ostensible sale? Ostensible sale is clearly which is not a real sale. So when one person transferring the property on the condition that this is the sale right now, which is not a real sale, but on the date of payment, if I made a default, yes, of course, this sale become your actual sale, and you will become the real owner of this particular property, the mortgage property. So this is the all concept of your mortgage by conditional sale. So when the mortgager ostensibly sell which not real sale, and this ostensible sale become void when the mortgager makes the entire payment of amount to the mortgagee. So with a condition that in case of default of payment on a specified date, the sale shall become the absolute. So such transaction is known as what? Your mortgage by conditional sale. So under the mortgage by conditional sale, yes, when a mortgager is transferring the property on the condition of ostensibly sale, and in the case of date of payments, if he makes some kind of default, so that sale will become your actual sale, or otherwise if he makes the entire payment of mortgage money, so in this situation the sale will actually be what? It's actually become a void sale, so ostensible sale remain void over here. So that's all about the concepts of your mortgage by conditional sale. Now we are moving forward to the question number 5. Please read the question and let me know what is the correct answer of this question as well. So the question is talking about a suit seeking the decree that the mortgager shall completely barred from redeeming the mortgage property is known as what? So what is the main important essential of mortgage? When I am talking about the essential of mortgage, it's an obligation upon the mortgager. On the due date, you will make up entire repayment of the mortgage money to the mortgagee. And if there is a transfer of actual possession of immovable property to the mortgagee, so it's a responsibility upon the mortgagee to transfer the possession to the mortgager over here. But in such of the cases, when the mortgagee is denying the fact that he will not be transfer the possession of the property, so in this case the mortgager can be exercised and file a suit for foreclosure. It means the whatsoever the possession he right now will lose, for the purpose of regain that possession, it become your suit for foreclosure. So this type of suit or benefit is granted under the mortgage by conditional sale. So suit for foreclosure is granted under the mortgage by conditional sale, and in this situation the mortgager has a right to completely take the take the loss of possession whatsoever he lost at the time of entering into mortgage transaction. So he can file a suit for foreclosure and take the possession of the property whatsoever he has lost at the time of entering into the mortgage transaction. So option number A, that is a suit for foreclosure, is absolutely be fine here. Now we are moving forward to the question number 6. So please read the question and let me know accordingly what is the correct answer of this question as well. So yes, the question is talking about when the mortgage property is leasehold and the mortgagee secure a renewal of the lease, the mortgager on redemption what? So in case when the mortgagee has obtained the renewal of the lease, so as per section 64 of the Transfer of Property Act, in this particular situation the mortgage get a new lease under these circumstances when the mortgagee has obtained the renewal of lease over here. So what is the correct answer? Shall not have any claim over the renewed lease, may terminate the renewed lease at his discretion, loses all the right under the renewed lease automatically, shall have the benefit of new lease despite of any contrary agreement. So if there is no any kind of subject to the provision of the contract, so if there is no any kind of agreement, then as per section 64 of Transfer of Property Act, in this situation the mortgager have the same benefit of the new lease in case the mortgagee has obtained the renewal of the lease over here. So option number D, if you are selecting, that's absolutely the correct answer. Yes, na? Now we are moving forward to the question number 7. Please read the question number 7 and let me know what is the correct answer of this question as well. So the question is talking about goods that are to be manufactured. So any of the goods that are to be manufactured, produced or acquired by the seller after entering into the contract of sale are known as what? So we have covered the exactly definition of goods. Goods means what, sir? Goods means movable property which include all the shares, all the stocks and trees, grass which is attached to the forming part of land. But we have severed before the making of any contract. Apart from it, we have excluded some of the things from the definition of goods, like your actionable claim and the money. Apart from it, goods have a different type. We have the three type of goods, that is your specific goods, existing goods and your future goods. When I am talking about the future goods, so after making the contract, any of the goods is yet to manufacture and yet to be produced, so that goods will become your future goods. And any of the goods which is right now in existence of my possession, it become my existing goods. Now these thousands of the pen I have right now in my possession, in the existence of myself, in my godown I have the 1000 of this pen, so this is my existing goods. But out of the 1000 of the pen, if I have selected and identified or specified one of the pen, it become your specific goods. So when I am talking about in relation to this definition, so goods that are manufactured or produced will become your future goods. So this question is related with your Sales of Goods Act. So if you are selecting here option number B, yes, of course your answer is correct right now. Okay, we are moving forward to the question number 8. So please read the question and let me know what is exactly the correct answer of this question number 8. So yes guys, when I am talking about the stipulations, so we have the two type of stipulation. So stipulation stand for your two things, that is your condition and your warranty. When I am talking about the condition, condition is your what? Condition is basically your essential part of the contract. So condition is your what? Essential part of contract. And when I am talking about your warranty, warranty is a collateral to the main purpose of the contract. So it become my what? Collateral to the main purpose of the contract. Collateral to the main purpose of the contract. And when any kind of condition is breached, yes, you can repudiate the contract, you can cancel the contract. And when I am talking about the warranty, in case of breach of the warranty, you cannot cancel the contract, you cannot repudiate the contract, but yes, you can claim the damages. Like let's say suppose I want electric pen. So right now this is the electric pen I want right now. So in this case, I ordered the one of the electric pen to some of the supplier, and the supplier delivered not electric pen but a normal pen. So what is the main purpose? The main purpose is to buy the electric pen. So can I say my condition has breached? And in case my condition has breached because my main purpose of the contract to buy the electric pen, but the supplier has supplied right now the normal pen, so it's my breach of condition. In case of breach of condition, I can repudiate the contract as well as I can claim the price of the pen as well. Apart from it, let's say suppose the supplier had supplied basically the electric pen, but I need a black electric pen, and he supply white electric pen or some of the other color. So right now I can claim the damages, but right now my essential purpose, the main purpose of the contract had not be breached. This is the reason behind it. I cannot be cancel the contract. I just be claim the damages. So right now when you are saying in this particular question, so warranty is regarded as stipulation which is collateral to the main purpose of the contract, and the breach of the warranty is entitled the aggrieved party to just be claim the damages, but such person didn't have any right to be repudiate the contract, that is he cannot be cancel the contract over here. Now we are moving forward to the question number 9. So just please read the question and let me know what is the correct answer of the question number 9 as well. So yes guys, this question is based upon your Sales of Goods Act 1930. So please read the question first of all. In case of unconditional sale of specific goods that are already in a deliverable state, the ownership of the goods is transferred to the buyer at what time period? So where I am talking about, this particular provision is related with your what? Related with your section 20 of the Sales of Goods Act. Section 20 is talking about when we have a unconditional contract of sale. So when the ownership, the property of the goods shall transfer. So the ownership and the property of the goods shall transfer at the time when the contract is made. So this is the most important provision we have right now. So it doesn't matter whether the buyer has paid the price or not, whether the goods has basically been delivered or not, it doesn't matter at all. But when you have an unconditional contract of sale, so the property and the ownership of the goods had transferred at the time of contract is made. So in this situation, what is the correct answer? So in this unconditional sale of specific goods, the property, the ownership of the goods is basically be transferred at the time of contract made. So when the contract is made, yes, all the property and the ownership of the goods will transfer. So only after the goods are physically delivered, when the payment consideration is completed, when the time of delivery and payments is fixed, both contract and delivery of the goods take place simultaneously, but no, immediately upon the making of the contract. It doesn't matter at all whether the goods has delivered, it doesn't matter at all whether the buyer has made the payment or not. So the option number E will become your absolutely correct answer. Now I am moving forward to the question number 10. Now this question is related with your Arbitration Act. So please read the question and let me know what is the correct answer of this question as well. So yes guys, when I am talking about in this particular situation, the question is saying if the parties to an arbitration agreement do not specify the number of arbitrator, then as per the Arbitration Conciliation Act, the arbitrator tribunal shall consist of what? So this concept is related with your section 10 of Arbitration and Conciliation Act 1996. What according to the Arbitration Conciliation Act section 10 is talking about? Section 10 is talking about the parties are free to determine. So both the parties are free to determine how many number of arbitrator he want to be appointed. So parties are free to determine. If the parties want, they can be determined the one arbitrator, they can be determined the 3, they can be determined the 5, 7, 9. But the most important thing is all the parties must be select and determine the arbitrator only in what? Only in a odd form, not in a even form. So you can determine the arbitrator but not in even or not in even number, because in a even number there is again the conflict of interest will arise. But in case if the party has not decided, if the parties not determined, so in case the parties is not be determined, so as per the provision of section 10 subsection 1, how many arbitrator in this particular scenario? So there is a one arbitrator who will adjudicate the entire matter. So the one arbitrator shall be appointed at all. So when I am talking about in this particular question, so what is the correct answer? So the two arbitrator, so arbitral is consist with your only one arbitrator, that is a sole arbitrator. So if you are selecting here option number B, yes, of course, your answer is correct right now. So this question is related with your Arbitration Conciliation Act and the entire concept is based upon your section 10. Now we are moving forward to the question. So before moving the question, this is your Telegram group. So still you have not been joined in the Telegram group. Make sure you just be search the Chartered as a Thagral. You can directly be joined in my Telegram group. Apart from it, you have also be the huge opportunity right now to be cover your phase 1 and the phase 2 syllabus. So just download the application of Oliveboard and you can be enrolled in the complete batch of your SEBI Grade A, under which you will get the live classes for phase 1 and the phase 2, where all the syllabus has been completed. And yes, you will going to be find so many upcoming session in the phase 1 and the phase 2 classes. Now we have the question number 11. So please read the question and let me know what is the correct answer of this question as well. Your time has started right now. So yes, the next question is talking about if the parties do not agree. So the parties do not agree on the place of arbitration, then it shall be. So when I am talking about the place of arbitration, we have the section 20. Now the section 20 of Arbitration and Conciliation Act is talking about, first of all, if the party want to decide the place, yes, as per the agreement by party. So the place will be as per the what? As per the agreement of party. So if the party had decided that we shall arbitrate this matter at this particular place, so as per the agreement of what? Agreement of party, you can be select the place of arbitration. The second case, if the party not decided, if party not decided, so in this circumstances, if the party has not decided which particular place they will arbitrate the matter, so in this situation the arbitral tribunal, so our arbitral tribunal will basically be decide the place. So they will decide the place which is more convenience to both the party. So they will arbitrate the matter at what place which is more convenient. So more convenient to the parties. The third provision we have, in case notwithstanding anything of the contract between the parties, yes, we have a one special provision, and the special provision is, so arbitral tribunal can also be decide the place. So your arbitral tribunal can decide the place where witnesses, expert and all the evidence shall easily be present. Shall what? Easily be present. So these are the three provisions we have right now at the time of determining the place of arbitration. So now, if the parties do not agree the place of arbitration, so as per section 20, subsection 2, what is the provision we have right now? The fixed by the court having the jurisdiction, determined by the parties under the court supervision, the place of sitting of the concerned high court, decided mutually by the parties selected by the tribunal, and determined by the arbitral tribunal depending upon the circumstances of the case. So if you are selecting here option number E, yes, of course, your answer is absolutely be correct. So that is the entire provision of your section 20 when we have in order to decide the place of arbitration. So if you are selecting your option number E, yes, of course, your answer is correct. Now we are moving forward to the question number 12. Please read the question and let me know what is the correct answer of this question number 12 as well. Yes guys, so what is the correct answer? So the question is talking about arbitral tribunal shall issue an order for termination of the arbitral proceedings. So when I am talking about the termination of arbitral proceedings, we have section 32. Yes, we have a very important section, that is your section 32. Now what is the section 32 is talking about? Section 32 is talking about the arbitral proceedings will terminate at the following situation. The first situation is when the arbitral award issued. So at the situation when the arbitral award issued, so the arbitral proceeding will be terminated. The second situation is when the claimant withdraw the complaint. So at a time when the claimant withdraw the claim. So this is the situation as well. The arbitral tribunal proceedings will be completed. And we have the third situation. And the third situation is what? The third, when there is no possibility of arbitration. So when there is no any kind of possibility of arbitration, so these are the some of the situations where the termination of arbitral proceedings happen. So now it find the continuation of the proceedings has for any reason become unnecessary or impossible. Now the award cannot be passed due to the lack of evidence. The dispute has rejected by the tribunal and the arbitral proceedings has prolonged beyond the prescribed time, and arbitral award has already been challenged before the court of law. So the option number A is the absolutely correct answer. When it is find that the continuation of the proceedings has for any reason become unnecessary or impossible. So it doesn't be matter to be complete the entire matter and the arbitral proceedings. Now onward it is not be seems possible at all. So in this situation there is a termination of arbitral proceeding as per section 32 of Arbitral and Arbitration and Conciliation Act. Now we have question number 13. So please read the question number 13 and let me know what is the correct answer of this question as well. Yes guys, this question is again very easy question. Yes na, because the question is talking about when a person who express his willingness. So as per section 2 subsection 2a, section 2 subsection 2a of Indian Contract Act 1872, so when one person is signifying his willingness to do or not to do anything, so it's just like a proposal. He is giving an offer to the another party. So the offer or proposal is what? When one person is express his willingness to do or abstain from doing with the intention of obtaining the assent of other person. So such expression is known as what? Proposal. So if you are writing your option A, that's absolutely be correct. But after that when the proposal has accepted, so when proposal accepted, it become your what? It become the promise. So this is the also the point which is important for examination. Now we are moving forward to the question number 14. Please read the question and let me know what is the correct answer of the question number 14 as well. So yes guys, as per section 2 subsection I of the Indian Contract Act. So when I am talking about this question, so as per section 2 subsection I of Indian Contract Act 1872. So this section is related with your what? Voidable contract. So voidable contract is a contract in which what? In which it is accessible or enforceable at the option of one or more party but not at the option of other party. When we say like that, when a contract has made without the free consent of other party. So when there is no any kind of free consent, so this type of contract which is enforceable at the option of one party but not at the option of other party. So this contract will become your what? Voidable contract. So when I am talking about the voidable contract, so it is not been enforceable at the option of one or more party, enforceable by law, not enforceable by law, enforceable law at the option of all the party. So if you are selecting here option number A, so not enforceable by law at the option of one or more party is the correct answer. Now we are moving forward to the question number 15. So please read the question number 15 and then let me know what according to you is the absolutely correct answer of this question as well. So the question is talking about contingent contract. So the contingent contract as per section 23, to do contract to do or not to do something if the uncertain future events does not be occur and can be enforced when the happening of that event become impossible, cannot be enforced by the law unless and until this event is happen, and the next is can be enforced on the happening of that event or cannot be enforced at all, and the last point is can be enforced immediately after the agreement is made. So when I am talking about this contingent contract is related with the enforcement of contingent contract section 33 of Indian Contract Act. So when you are reading the section 33 of Indian Contract Act, it is clearly be mentioned at the time of when you are entering any kind of future contract, it means any of the contract which is in the contingent in nature. So it can be enforced when the future contract and whatsoever the event which is not be happen and it become impossible to be happen. So when any kind of event can be enforced when the happening of that event, so happening of that event become the impossible to perform, so such kind of contract is the enforceable at all. So option number A is the absolutely be correct. Now we are moving forward to the question number 16. Now please read the question again and let me know. This question is related with your special contract of guarantee. So please read the question first of all and let me know what is the correct answer of this question as well. Yes guys, the question is talking about if a person furnish a guarantee on a understanding that the creditor will not act upon it until the another person join as a co-surety. Let's say suppose we have a Mr. A. We have a Mr. A, then we have the Mr. B, and right now we have the Mr. C. So this is the situation where Mr. A is a principal debtor, Mr. B is a creditor right now, and your Mr. C is a surety. Now right now the creditor has put a one of the condition. The condition is very simple, that the creditor will not act upon it until the another person join as a co-surety. So what is the condition right now? The condition of Mr. B is very simple. The condition is talking about if the Mr. D who is act as a co-surety, if they will not be enter into the contract of surety. So if that Mr. D is not be enter into the contract of surety, so this particular contract of surety will become your what? This contract of surety become invalid. So this is the condition of the creditor over here. So when you are reading the question, so it is talking about if a person furnish a guarantee on the understanding that the creditor will not act upon it until the another person join as a co-surety. So the contract become voidable at the option of creditor. The surety continue to be bind despite of the non-joining of the co-surety. The guarantee does not take effect unless the other person join as a co-surety. So when I am talking about the option number C is the correct answer, sir. So your contract of surety will not be valid at all until the Mr. D will join in this contract of surety over here. So when I am talking about the option number C, yes, of course, the option C is absolutely the correct answer. Now we are moving forward to the question number 17. So please read the question number 17 and let me know what is the correct answer of this particular question as well. Yes guys, so the question is talking about the specific relief under the Specific Relief Act granted for the purpose of what? Enforcing the criminal liability, enforcing the collective public rights, enforcing individual civil right, enforcing the personal penal obligation, enforcing the administrative directive. So option number C is correct answer. So let's say suppose Mr. A and the Mr. B, they have entered into a contract that Mr. A will transfer the immovable property at the valuable consideration of 50 lakh. But later Mr. A has breached the contract. So in this situation, Mr. B can be request in the front of court of law that please ask the Mr. A to perform a specific performance, that is please ask the Mr. A to sell the immovable property at the valuable consideration whatsoever we have agreed. But he cannot be asked for any kind of Indian Penal Code provision, that is for a punishments for like this you cannot be asked, but for a specific performance under the Specific Relief Act you can be asked in the front of court of law. So when I am talking about this particular question is related with your enforcing the individual civil right. So you can be enforce the individual civil right rather than any kind of penal provisions. Now we have the question number 18. So please read the question number 18 and let me know what is the correct answer of this question as well. Yeah, Pradeep sir, you can be asked here. Anything you want to be asked, please. ask in the comment box. I will definitely be reply your all the queries and the question. Yes guys, so what is the correct answer? So the question is talking about a suit for recovery of possession of immovable property by a person unlawfully disposed of without his consent and otherwise then in the due course of law must be filed. So when I am talking about under the Special Relief Act, in this particular situation where a one person has dispossessed the immovable property but without his pure consent and without following the due procedure of the law, so in this situation he can lodge a suit against that particular person but not against the government of India. So if the government of India is taking your any kind of immoral property or any kind of possession of your immoral property, so in this situation you cannot be lodge any kind of suit. But apart from it, without your consent, if you have dispossessed any kind of possession of your immoral property, so you can be take the legal action but within a 6 month from the date of disposition of immoral property. So when I am talking about, it's a 3 year from the date of disposition, 2 year from the date of disposition, within a 6 month from the date of disposition is the absolutely correct answer. Now we are moving forward to the question number 19. So please read the question number 19 and let me know what is the correct answer of this particular question as well. Yeah, Pardeep sir, you can be just drop me the telegram. Yes, you can drop me your message, your telegram, Chartered Ajay Thakral. You can just be search on your telegram, Chartered Ajay Thakral, and you can be find me. And definitely, I will definitely be help you out in any of the guidance whatsoever you want. So just search on your telegram, Chartered Ajay Thakral, and just drop me the message. Definitely after the class, I will connect with you. So this concept is related with your what? This concept is related with your expeditious disposal of suit under the Special Relief Act. So this concept is related with your section 20C of Specific Relief Act. So when I am talking about in this section, yes, there is an obligation, not withstanding anything contained in the Civil Procedure Code. We are not be standing with whatsoever written in the Civil Procedure Code. But if any of this suit has filed in front of the court of law, it's a responsibility upon the court of law to be resolved and dispose of the entire suit application within a period of 12 months from the date of summon. So the court has an obligation. So court has obligation. And what is the obligation? The obligation to dispose of the case, dispose of suit. And what is the time period we have? So the time is within a 12 months, within 12 months from the date of summon. So from the date of what? Date of summon. The next important is in case of extension. In case of extension, the extension shall be granted but only up to the period of extension shall granted only up to 6 months, but the court must record the reason in writing. So what is the correct answer? Within a 6 month from the date of service of summon, within a 6 month from the date of institution of the fine, 12 months from the date of filing the plaint, within a 12 months from the date of first hearing, and within a 12 months from the date of service of summon to the defendant. So we have covered the entire section, that is your section 20C. So if you are selecting here option number E, definitely your answer is correct. Now we are moving forward to the question number 20 over here. So please read the question and let me know what is the correct answer of this question. प्रदीप सर, ये रहा चैनल का नेम, आप मुझे यहाँ पे मैसेज कर दीजिए। ये बार कोड आपको दिख रहा होगा, चार्टर्ड अजय ठकराल, या तो आप सर्च कर लीजिए या आपके सामने ये बार कोड होगा, इसको स्कैन कर लीजिए। सेशन के बाद मैं आपसे कनेक्ट कर लूँगा। तो मैंने आपको बताया था चार्टर्ड अजय ठकराल सर्च करने के लिए, CHARTEREDAJAYTHAKRAL। तो आपको मैं टेलीग्राम चैनल पे मिल जाऊँगा और इस सेशन के बाद मैं आपसे कनेक्ट कर लेता हूँ। Now please read the question and let me know what is the correct answer of this question as well. So yes guys, when I'm talking about the partnership at will, so the partnership at will refer to the partnership what? So partnership at will, it means the partnership will continue at the discretion of the partner. But when I'm talking about the dissolution of partnership at will, so any of the partner, when they are giving a notice, the notice of dissolution, so if that notice is mentioned the date of dissolution, so from the date of dissolution entire the partnership will going to be dissolved if it is consented by all the other partner. But when there is no any kind of date has given in the date of notice, so in this situation your partnership at will going to be dissolved at what particular days? At the date of communications and the date of notice communicated to all the other partners. So this is all about your partnership at will. So when I'm talking about formed a fixed duration upon the period of contract created with the consent of all the partners, that can be dissolved by mutual consent of the partner, and when there is no provision regarding the duration or mode of determination of the partnership, so option number D will absolutely be correct in this scenario. Now this is the Telegram group, you know very well. Now we are moving forward to the question number 21. So please read the question and let me know what is the correct answer of this question as well. So the correct answer is what? When a partnership entered between a B and C and the sole purpose of completing a specific construction project and sharing the profit equally. So right now they have a one specific purpose. The one particular purpose they have created the partnership. So once the purpose will accomplish, yes of course the partnership will going to be dissolved. So when I'm talking about this type of partnership is your particular partnership. So if you are selecting here option number B, yes of course your answer is correct. Now we are moving forward to the question number 20. So please read the question and let me know what is the correct answer of question number 22 as well. So the question is talking about under the Indian Partnership Act, a minor may be admitted to the benefits of existing partnership. When I'm talking about is the minor become partner of any partnership? No sir. Minor cannot be become a partner in any of the partnership. The reason is very simple. Minor is an incompetent person, and because minor is an incompetent person, he cannot be enter into any of the contract. That by the reason, yes of course he cannot become a partner in a partnership firm. But when I'm talking about can he admitted as a benefits of the partnership? Yes, if all the partners, the 100% majority has given by all the partners in this situation, yes, you can be enter the minor into the benefits of partnership. So what is the correct answer? Only if all the partner give their consent, majority of the partner approve by permission of the court, automatically without the consent of the partner. So option number A is the correct answer. If all the partner has given the consent to admission of this minor, yes of course you can be admit into the benefits of partnership. Next question, we have the question number 23. So please read the question and let me know accordingly what is the correct answer of this question as well. So the question is talking about if a partner while acting in the ordinary course of the firm business commit any kind of wrongful act or omission causing a loss or injury to the third party. So if any of the person who commit any of the act but in the ordinary course of the business, and because of such act if the third party incurs some of the losses, so for all the losses who will be liable? The partnership firm will liable, but only to the extent of loss actually will happen because of the act of his existing partner. So that is the reason behind it when I am talking about what is the correct answer. So the firm is not responsible for such act, only the concerned partner is personally liable. The firm is liable to the same extent as that of partner. So if you are selecting here option number C will be absolutely correct answer. Now we are moving forward to the question number 24. So guys, please read the question number 24 and let me know the correct answer as well. So yes guys, what is the correct answer? Subordinate legislation refer to a situation. So in a subordinate legislation, your primary legislation is giving a power to some of the body, some of the person to implement the law. Now just take the example of Government of India issue the circular and the orders and the rules. They are framing the rules and the regulations so that it can administer the primary legislation. So that is exactly your subordinate legislation. So when I am talking about subordinate legislation, what is exactly mean? Legislation framed for the own internal functioning. Parliament retain all the law making power. The judiciary interpreted the law made by the legislature. Parliament enacted the law governing conduct of the executive, and the option number E is correct answer. The executive is authorized. The executive is authorized by the parliament and the primary legislation to make a detailed law under his supervision, so that that particular law can be administered and implement for a better laws made by the primary legislation, that is a parliament. So just like a order, rules, regulations framed by the recognized authority is just your subordinate legislation. So option number E is absolutely the correct answer. Now we have the question number 25. So please read the question and let me know the correct answer as well. So this concept is related with your what? This concept is related with your application of law. So when I am talking about the application of law, we have the two of the prospective. One is prospective statute application and the retrospective. When I am talking about the prospective application, it means the any kind of law, the provision of law will be applicable from the future date. Or when I am talking about the prospective, so retrospectively means when the act or statute and the provision of law is implement or applicable from the past part itself, and it is also be applicable to the future of the cases as well. So this is the difference between your prospectively implementation and your retrospectively implementation. So when I am talking about in this question a law that apply only to the events occurring after it has enacted and not to the action before its commencement. So in these situations this law is applicable for the future of the time period. So that's why the reason it is known as prospective statute. So in a prospective statute the law and the provision of law will be applicable from the future date, but in retrospectively that law or provision are applicable from the past of the dates. So this is the difference between your retrospective and your prospective. Next question, we have the question number 26. Read the question and let me know what is the correct answer of this question as well. So the question is talking about a person who reside in Delhi publish a defamatory statement about B, a resident of the Mumbai, in a newspaper printed in Calcutta. In this case, B may institute a suit against A at what of the place. So when I am talking about this provision is related with your civil procedure code, and as per the provision of civil procedure code, if one person has something wrong from the act of this some other person, so such aggrieved person can take the legal action at what the place of court where he is right now residing, or at any of the place where the wrongful act has committed, or even at the place of the court of law where the defendant are right now residing. So at the option of that aggrieved person, they can simply be lodge a complaint against of the such wrongdoing person. So only in Calcutta, only in Delhi, only in Mumbai, either Delhi or Calcutta. So right now a person who reside in Delhi publish a defamatory. So in this case, either the B may file a suit in the place of Delhi, either the B who is resident of Mumbai, he can file the complaint in either a Calcutta. So this is the reason behind it, either a Delhi or either a Calcutta, he can simply be lodge a suit against the Mr. A over here. Now we have the question number 27. So please read the question and let me know the correct answer as well. Yes, guys. So the question is talking about a suit under the Code of Civil Procedure. So the civil suit under the Code of Civil Procedure shall be instituted by submitting what? A single plaint directly to the court, a plaint along with a copy to the defendant, a plaint filed through an advocate to the court, a plaint in duplicate only to the presiding officer of the court, and a plaint in duplicate before the court or officer designated. So what do you think right now? What is the correct answer of this particular situation, guys? In this scenario, the correct answer is a plaint in what? In a duplicate to the court or such of the officer designated by it. So if you are selecting option number E, so option number E is the absolutely be the correct answer. So when you are raising any kind of civil suit, it's a responsibility upon that person. You must be present the plaint in front of the court or the officer designated by it. Only then your suit shall be acknowledged, otherwise not. So option number C is the correct answer. Now we are moving forward to the question number 28. So guys, please read the question and let me know what is the correct answer. If the plaintiff failed to disclose the cause of action, then what the action of court? Yes, guys. So what is the correct answer? Under the order 7th rule 11 of the Code of Civil Procedure. If plaintiff fails to disclose a cause of action, now in this case the court shall reject the plaint. Now what is the reason behind it, sir? Reason is very simple, because when I am talking about as per the rule 11 of order 7, it is clearly mentioning that in case when the plaintiff has not been submitted or actual disclosed the cause of action, when the plaint is not be filed within the time period of limitations, when actually your whatsoever the plaint is not be presented in a duplicate copy form. So these are the situations where the court will reject your plaint over here. So that is the most important point, because right now you have not been disclosed the cause of action. So in this case the court shall be reject your plaint. And one more circumstances where the court shall reject your plaint, that is your when you have submitted the undervalued stamp paper, or your paper plaint is not be sufficiently be stamped. So these are the situations where your plaint shall be rejected by the court of law. So option number A is the correct answer. Now we are moving forward to the question number 20. So read the question number 29, sorry, and let me know what is the correct answer of this question as well. So the question is talking about if the counterclaim has filed in a civil suit and the main suit is subsequently be dismissed, the counterclaim will what? So the counterclaim will what? If the counterclaim has filed and the main suit is subsequently be dismissed. Let's say suppose Mr. A filed a suit against the Mr. B for the non-payment of 2 lakh rupees and later he withdraw the suit. So in this case, when the Mr. B has make the counter claim that yes, right now the non-payment amount is only 1 lakh because earlier I already be paid the 1 lakh rupees, so the non-payment amount is 1 lakh. So in this particular case, the counter claim will be proceed over the actual claim, and in this scenario the Mr. B is liable to pay to the Mr. A for the 1 lakh rupees of the amount. So the automatically stand dismissed along with the main suit may still be continued and decided on its own merit. So option B is the correct answer in this case at the time of counter claim. So it may be continued and it can be decided at its own merits over here. So if you are selecting option number B, so option number B is the correct answer. Now we have the question number 30. So please read the question number 30 and let me know the correct answer as well. Yes guys, the question is talking about if a person B through intentional or negligent conduct cause the unauthorized interference with the C possession or enjoyment of movable property, chattel, such interference amounts to what? The tort of negligence, the tort of trespass to the goods, tort of vicarious liability, tort of conversion, and the tort of nuisance. So option number B is the correct answer. It's a tort of trespass to the goods. When I'm talking about the trespass, what is exactly the meaning of, sir? So trespass relation to your property itself and it relate with your chattel itself. So when a Mr. A has entered in the immovable property of Mr. B, let's say suppose in the garden of Mr. B, and right now he is working in the garden of Mr. B, Mr. A without the permission of Mr. A. So in this particular situation, Mr. B has actually breached the some of the offense under the tort of trespass, because without the permission of the owner of the immovable property, you are working in the garden of that immovable property. So in this situation, it's a trespass of the property. But when I'm talking about the trespass of the good, it means when Mr. A who is legally possess the laptop, but without the permission of Mr. A, you simply bring such laptop and using for a 1 day without such permission of Mr. A over here. So again, it's a trespass to the chattel. Chattel means any kind of goods in which the owner has a legal possessions, and without the permission of the owner, if someone has obtained the possession of such goods, so it's a trespass of the goods over here. So that's why the reason, what is the correct answer? Option number B, the tort of trespass to the goods over here. So if you are selecting option number B, yes, of course your answer is correct. This is your Telegram group. Make sure if you have any kind of doubt, you can simply reach me out. Apart from it, if you want to prepare the complete course of SEBI Grade A, you can be enrolled now in your SEBI Grade A complete course. Just you have to download the application of Oliveboard, where you will get all the classes of phase 1 and the phase 2, where all the 100% syllabus will going to be complete in your in your Oliveboard application. So make sure download the app and start your preparation for SEBI Grade A examination. Now guys, we have the question number 31, and this question is related with your Indian constitutions. So let me know in the chat box what is the correct answer of this question as well. Yes, we have the next question, and the next question is, which of the following provision of Constitution of India guarantee the principle of equality before law? So your Article 14 is talking about it doesn't be matter at what the birthplace is your, it doesn't be matter what is the religion you are following, it doesn't be matter what is your caste, but yes, all the person will be equally be treated in the eye of law. That is the protection of Article 14. So the Article 14 is giving a protections to all the person within the territory of India. It doesn't be matter where it is your birthplace, it doesn't be matter what is your caste, it doesn't be matter what is your sex, that is you are male or female. Yes, there is a equal protection of everyone in front of the law. So when I am talking about the Article 14, so the Article 14 is the absolutely correct answer. It's a equality before law. Now we are moving forward to the question number 32. So please read the question and let me know accordingly what is the correct answer of this question as well. Yes, the question is talking about under which of the provision of Constitution of India it's a abolition of title is specifically be provided. So when I am talking about its Article 14 equality before law, Article 18 abolition of title, option number B is the correct answer. So the abolition of the title, that is Article 18, is giving a protection to all the person or to all the citizen of India. The reason is very simple, in order to protect from the inequality. So the social injustice not be happen, that is the reason behind it. Article 18 is protecting all the benefit over here, like a government of India. Government of India didn't be use the name of Raja, Sir, like of this title, that will give the prestigious to such of the government. Apart from it, any of the person didn't be use any kind of such of the title with their name, which give a social prestigious at one particular place. But apart from the, we have some of the exception. The exception is at a military duty. In a military, you know very well, we have the different name, the prestigious name we have like colonel. We have some of the prestigious name that exactly be given to the rank of the officer we have in the army. So yes, they can use the such of the title, but apart from the army officers or the military persons, no one can be used such of the persons. Apart from it, we have one more exception, like the person who is giving us some of the professions, who are doing some of the profession, like a doctor, like an engineer. So in this case, the doctor can be used the some of the title, like doctor in the front of his name as a title. So Apart from these of the person, no one will be use any of such of the title which gives some of the prestigious in the social that will create the social injustice. So this is the reason behind it. Article 18, that is abolition of title, is the correct answer. Now we have a question number 13, and please read the question number 13 and what according to you is the correct answer. Please give me the answer in the chat box. So the question is talking about Article 21. Now the Article 21 of the Constitution of India inserted to provide for what? Free education to all children below the 15 years of the age, compulsory education to be provided by the state, compulsory education to all the children above 6 years of the age, free education to all the children between the age of 6 and 14, and free and compulsory education to all the children between the age of 6 and 14 years. So right now we have option number E, free and compulsory education. It means it's a responsibility upon the state under Article 21A, that is every children who is in the age range of 6 to 14, they will get compulsory, mandatory and the free educations during the time period of whatsoever the academic he is doing. Apart from it, if it's not be responsibility given to the state to give some of the higher education profession or professional education, no. But for a 6 year to the 14 year of the children's, yes, they will get definitely a free education and mandatory education from the state. So what is the correct answer? So as per Article 21A, option number A is absolutely be correct. Now we are moving forward to the question number 13. So please read the question and let me know what is the correct answer of this question as well. So the question is talking about the constitutional. The constitutional provision is stating that no person shall be deprived of his life or personal liberty except according to the procedure established by the law is contained under which of the article? Article 32 of the Constitution of India, Article 21, Article 45 and 14 and 21A. So yes, exact sir, we have recently be completed the Article 21A. So it is not the correct option. So what is the correct option? Option number B. Option number B is talking about every person has a right to life and right to free liberty. So that is the main behind the logic behind it. Article 20 is giving a right to all the citizens of India that they have the right to live and they have the right to personal liberty. So if you are selecting the option number B, yes, of course your answer is correct right now. Now we are moving forward to the question number 35. So please read the question and let me know the correct answer as well. So the question is talking about, as per the Article 129 of Constitution of India, the Supreme Court exercise the advisory jurisdiction, function as the guardian of Constitution, act as the highest appellate court only, has original jurisdiction in dispute between the state and union, and is a court of record, possess the power to punish for its own contempt. So option number E is the correct answer. The Supreme Court has the power of the court of record. It means right now, if any person who will do the contempt of the Supreme Court, yes, they have the power even for a contempt of court. That particular person will be punished by the Supreme Court. So the Supreme Court has all over the power under the court of record. So if I am talking about the option number E, yes, of course, the option number E is correct answer, because the Supreme Court has the power of court of record and possess the power to punish for its own contempt. Now I am moving forward to the question number 36. So read the question number 36 and let me know accordingly what is the correct answer of this question as well. Yes guys, the question is talking about the name of state and the union territory in India are specified under which of the following. So the Government of Union Territory Act 1963, the State Reorganization Act 1956, the first schedule of Indian Constitution. So when I am talking about the first schedule of Indian Constitution, it clearly be mentioning the name of the states and their territorial boundaries. What is the territorial boundaries we have, including the union territory? So if you are selecting here the option number C, option number C is correct answer, because it is dealing with the first schedule of Indian constitutions. Now we are moving forward to the question number 37, and please read the question number 37 accordingly and let me know what is the correct answer of this question as well. Yes guys, so the correct answer is, so the question is talking about, as per the directive principle of state policy, which article mandate the state to ensure the separation of judiciary from the executive in the public service of the state. So yes, there is a separation of judiciary and the executive power. In order to ensure that the executive will not influence the judicial officer, that is the reason behind it. Article 50 has given the clearly indication there is a difference between the exactly separation of judicial and the executive power. So under the directive of principle of state policy, and the Article 50 is clearly depicting that there is a separation of judiciary from the executive, so that the judiciary is not be influenced under the administrative power of the executive. So option number B is absolutely the correct answer. Now we have the question number 38, So please read the question number 38 and let me know the correct answer as well. So what is the correct answer? So the question is talking about the governor. The governor of the state may entrust to the state government or its officer function related to the matter within the state executive power. So on his own discretion, with the consent of the president, on the direction of the central government, with the consent of the government of India, and with the consent of the government of the state. Now, please let me know what is the correct answer of this particular question, guys. It's a very simple. Yes, option number D is the correct answer. So with the consent of the government of India, yes, it is given a power to the governor of the state either conditionally or either unconditionally. Yes, they have entrusted to the state government, they have entrusted to the officer functions. So in order to prevent from the any kind of disaster or any kind of things, they can mutually be decided. So for that particular purpose, in this scenario, with the consent of government of India, the governor may be entrusted to the state government or its officer within the state executive power, and the option number D will be your correct answer. Now we are moving forward to the member composition, the council of member composition, council of minister composition. So let me know, according to the article 75(1)(a) of the Constitution of India, the strength of council of minister, including the prime minister, is restricted up to what? So when I am talking about the correct answer of this case, so the strength of council minister. So when I am talking about the strength of council minister, so including the prime minister is initially be restricted up to 15% of what? Houses of people, that is your Lok Sabha. So including it is restricted not more than 15% of total membership of the Lok Sabha, not more than 12% of the total membership of the Lok Sabha, 10% of the House of People, and 18% and 20%. So option number A. So including the Prime Minister, the council of the minister shall not exceed with the 15% of total membership of the Lok Sabha. So if you are selecting here option number A, yes, of course your answer is correct. Now we are moving forward to the question number 40. So kindly read the question number 40 and let me know what is exactly the legal term of conscious ad idem. So guys, conscious ad idem means the meeting of the mind. There is a mutual agreement between the party. So both the party will be treat each and every one, and they are entering into one of the contract in which they are agreed with the same sense, with the same term, that is your conscious ad idem. So conscious ad idem is generally a Latin word which prescribe here the same opinion on the contract, meeting of the minds, consent on the same idea, similar consent on the contract of the term. So generally conscious ad idem refers to the meeting of the mind. The meeting of mind on the same thing in the same sense on the same idea. So option number B is the correct answer. Now before moving ahead, you can simply be join in my Telegram group as well in case of any doubt and the further clarification whatsoever you want. Now we are moving forward to the question number 41, and the question number 41 is dealing with your friends of the court. Friends of the court means what? And the friends of the court is exactly which of the term is clearly be depicting the friends of the court. So yes guys, when I am talking about the friends of the court, so actro incumbit justem generis amicus curiae ad hominem bona fide. So option number C is the correct answer, amicus curiae. Friends of the court. The friends of the court is exactly meaning of what, sir? Like it's just like a advisor of the court. When a one person has appointed by the court of law which is not the party to the suit just for giving a advice on any of the term of the law, so in this situation such person is known as friend of the court, or in a legal term it is known as amicus curiae. So if you are selecting option number C, yes of course it is the correct answer. Now we are moving forward to the question number 42, and the question number 42 is talking about obiter dicta. So what is exactly the interpretation of your obiter dicta? So obiter dicta is your what? Obiter dicta is same like when any of the judgment of the court, any judgment and opinion of the judge, where it is not actually be the part of final decision of the court, which is not legally be binding on both the party. So such is known as such suggestion, such judgment, such information is representation of obiter dicta. So dictation formally issued by the court, a specific order declared as a part of decree, obligation imposed directly by the judiciary, a direction explicitly binding on the parties. So the statement, it's statement made by the judge in a passing and which is not forming part of the binding judgment. It's not a final judgment, it's just like a opinion, it's just like a judgment which is not the binding on both the parties. So right now option number E is the correct answer because it's the correct interpretation of obiter dicta. Next we have the question number 43, and the question number 43 is talking about the corpus delicti. So the corpus delicti is used in the criminal law to signify what? So corpus delicti is used in the criminal law to signify what? To signify it's a body of crime, criminal decision based on corpus, deceased person body or decomposed body. So it's a body of crime. Body of crime is before put any kind of investigations and any kind of evidence, you must be proof there is yes the crime has committed. So when the crime has committed, only then the further investigation and the action shall be taken. So when I am talking about, it's a corpus delicti. So the corpus delicti is simply meaning it's a body of crime. It's a proof that the crime has committed. Only then the further investigation and the action shall be taken. So option number A is the absolutely correct answer. Now we are moving forward to the question number 44. So please read the question and let me know the correct answer as well. So it is talking about which of the Latin maxim denotes a violation of legal right without the causing actual loss or damages. So volenti non fit injuria, injuria sin damnum, actus die nemini facit injurium, ex injuria jus non oritur, and damnum sin injuria. So injuria sin damnum is the correct answer. When a one person is actually without having any kind of special damages, when any kind of wrongful act is happen, just like a defaming of one of the person. So when a one person is defaming some of the reputed person, so there is a loss of reputation, but without any kind of special damages. So this is the reason behind it. Yes, in this scenario the court shall be give some of the nominal damages. In this situation, any of the case when it is found there is a injuria sin damage. Injuria sin damage is it's without any special damage when there is a loss of reputations, when there is a loss of some kind of, you can take the example of false imprisonment like a tort. So these kind of example of your injuria sin damage. Yes, damnum. Now we are moving forward to the question number 45, and please read the question and let me know the correct answer. So what is the correct answer, sir? So when a list of the specific word is followed by general word, the general word are interpreted in the same kind or same sense in the specific one. This principle is talking about ejusdem generis. What does exactly mean, sir? Like just take the example of the law is mentioning, if the law is mentioning one of the word like an animal, so it include the animal of cat, dog, and any of the animals. So when I'm talking about the other domestic animals, so it exactly the meaning of your some of the animals which is related with your cat, dog, and so on. Just take the example of another example where the law has mentioned the vehicle. So the vehicle is exactly interpretation of your word. The interpretation is car and your any kind of motorcycle like this. But when I'm talking about the other vehicle is related with your car and the motorcycle itself, like a bus and so on. But we cannot be assume the vehicle include the aircraft, the vehicle include a vessel. It is not be like that. So it's the same kind of the same sense. So when we have any kind of general word which is interpreted in the same class on the same specific one, so this principle is prescribed under the agestum generis. Now we have the question number 46. Now please read the question number 46 and let me know the correct answer as well. So the question is talking about any kind of fault, any kind of imperfection or inadequacy in the quality, nature or manner of performance of services by law or contract is termed as warranty. It's a deficiency. When I'm talking about the deficiency, it is the part of your Indian Consumer Protection Act 2019. So the Consumer Protection Act 2019 clearly be mentioning when there is a deficiency, it means the shortcoming of any kind of quality of the goods, any kind of shortcoming of the services performed. So these all are the example of your deficiency. So if any of the consumer who face the deficiency of the goods or services, he can lodge a complaint under the Indian Consumer Protection Act 2019 and accordingly he claim the damages. So when I'm talking about the option number B, yes, of course the option B is the correct answer. Now we are moving forward to the question number 47. So please read the question number 47 and let me know the correct answer as well. So the statement, thou art to be hanged not for having a stolen a horse, but in order that the other horses may not be stolen, reflect the principle of what? So what is exactly this principle? This principle is talking about when a one person has committed any criminal act. So our judiciary have not the objective just to punish for this criminal act, but the objective should be like that such kind of criminal act will not be repeated in the future itself. So in a future there is a low number of the criminal cases, so we will be punished accordingly. So the deterrent theory, our deterrent theory is talking about you should be punished to the criminals if any of the criminal perform any of the criminal act, not for the objective of punishment, but for the objective of creating a fear in the mind of some of the criminal. If you will do such of the criminal act, now these are the consequences that you will definitely be bear. So the objective is to create a fear in the mind so that there is a lower the chances of the criminal act will be performed by the such of the criminals. So this is the reason behind it, and this principle is clearly be depicting your deterrent theory over here. Now we are moving forward to the question number 48. So please read the question number 48 and let me know the correct answer. What is the correct answer of this case? Yes guys, so the question is talking about whoever intentionally use the force against another person without the consent with the intent to cause injury, annoyances to be commit what? Criminal force, assault, battery, force and assault by the force. Option number A is correct answer, criminal force. So any kind of force without the intention or with the intention you are using and for the objective without the consent of other party. So without the consent of other party, if one of the person using such of the forces, so which may cause some of the injury, which may cause some of the damages to the other person, so it's a criminal force. So it will be treated as a criminal force and such person will punished accordingly. So whoever intentionally use any of the forces against the another person without the consent and cause some of the injury, fear or annoyance, it's a criminal force over here. So we have a second last question of the day. What is exactly the jurisprudence? What is your jurisprudence? So when I am talking about the jurisprudence, it's a knowledge or study of law, procedure established by law, rule of law, justice or interpretation of law. It's a knowledge or study of law. Jurisprudence is exactly an English derivation. In a Latin word, it is jurisprudentia. It is known as jurisprudencia. It means it's a knowledge of the law, it's a study of the law. So that is the reason behind it. Option A is the correct answer. Now guys, we have a last question of the day. That is the 50th question. So please give your answer and let me know the final answer of this today's class. Yes. So what is the correct answer? So when I am talking about here, according to Solomon, a jurisprudence is defined as the body of principle which is recognized and applied by the state in enforcement of the sanction, administration of the justice, regulation of the conduct, pursuit of the justice and administration of the executive. It's an administration of the justice. So option number B, this is the correct interpretation of the Solomon jurisprudence. They have defined it's a body of principle and applied by the state in the administration of the justice. So that's all about the today's 50 questions. So we have completed the total 50 question. Now some of the question related to your more we have like a question number 51. What does exactly meaning of contract as per the Indian Contract Act? Now some of the question is very quite easy, so we will not be spent sufficient time on it because altogether in the last of the previous class it means the 2024 PYQ analysis we have already be covered these of these somehow interrelated questions, but you know very well in the examinations some of the question is exactly be matching. That's why the reason these are the questions which is you find some of the question which is related with your previous class, that is your PYQ 2024 analysis. So when I'm talking about the contract is your what? Contract is framed with the two of the word, that is your agreement and the second is your enforceable under the law. So when I'm talking about the contract, so contract is in agreement plus enforceable of law. So if the two condition has fulfilled, yes, we can be say it's a contract over here. So a contract is agreement enforceable by law. When I'm talking about the substitution of old contract with the new one, so when you're substituting the old contract with a new one, so it is actually with the novation of the contract. So we have a different types of contract. One is executed contract, executory contracts, your substitution of the contract, your rescission of the contract. So rescission means when you are cancelling or rescinding all the terms of the contract, and substitutions means you are simply when you are replacing the old contract with the new one, it becomes the novation of the contract. Now confession in the front of the police officer when valid. So when any kind of confession has given in front of the police officer is not valid at all, but when the confession has given in front of the magistrate, that always be valid over here. So when I'm talking about, so it's not valid under any circumstances, no sir. Valid corroborated with the other substantial evidence, weak evidence and the valid in the presence of the magistrate. So any kind of confession has been given in the front of the magistrate, that absolutely be valid over here. Now we have a decree holder. A decree holder is a what? A decree holder is simply that person in whom favor the decree has issued by the court of law. You know very well, decree, we have a two type of decree. Basically it's a three type of decree, but yes, initially we have the two type of decree, that is your preliminary decree, second is your final decree. When I'm talking about the ex parte decree, so ex parte decree is also be the decree which is given at the only the evidence of the one party, but other party has not be presented any kind of claim and any kind of document within a specified period of the time. So the court is announcing whatsoever the judgment by only upon the action of one party, it's ex parte decree. Then we have final decree. After adjudication made, the final judgment and the reward has issued by the court of law, it's a final decree. And then accordingly we have the preliminary decree which is not the final decree. So when I'm talking about the decree holder, so any person in whom the favored decree has been passed. Then we have the final question of the today's class. When does an arbitration proceedings actually be commenced? So when I'm talking about the commencement of arbitration proceedings, so if there is no any kind of agreement between the parties to the arbitrator, so the arbitration shall commence at the time when the request of dispute is received by the defendant. So when the request for dispute is basically be received by the respondent, so accordingly your arbitration proceedings will be commenced over here. So this is all about your today's 55 question, that we have be completed the 2022 and the 2023, the two previous year question set we have covered in this session. Now when I'm talking about in the 2022 SEBI Grade A legal officer exam, so in this particular scenario, you know very well, in 2022 we have some of the company law provision, but when I'm talking about in your 2025 or 2026 examination, you know very well, company law is the part of your what? Company law is the part of your phase 2 examination. Yes, so initially in 2022 company law is the part of your phase 1. That's why the reason all the questions related to your Companies Act we will be covering in the phase 2 of the classes when we will start the PYQ for a phase 2. But that's all about the today's session. We have successfully completed all the 55 question, guys. If you like the session, please click upon the thumbs up button and do like the session, as well as you can be share with your friend as well. Apart from it, if you want to be prepare yourself for a SEBI Grade A legal exam, yes, you can be download the application of Oliveboard and you can be enroll now in the SEBI Grade A legal complete course batch, where you will get all the live classes of phase 1 and the phase 2, as well as you will get all the detailed notes and e-PDF notes, mock test for your phase and phase 2. So all the team is right now ready for your successful examination completions. We have bring such of the complete course that definitely help you a lot, and these are the some of the screenshots for all those candidates who have actually the qualify his examinations, and right now they are in the well deserved position. So these are the some of the screenshots for those aspirants who already be selected in their respective examination. So that's all about the today's session. So if you like the session, don't forget to click upon the like button and do share the session. If you want to be prepared the complete course, yes, we have the complete course as well. Just for that reason, you have to be search on a Oliveboard. So when you write on a Google Chrome the Oliveboard, you will find the application in your Google Play Store, as well as you will find the website of Oliveboard. So just click upon the regulatory, and after scrolling down you can find a SEBI courses. So in the SEBI courses you will find the SEBI Grade A legal complete course. So in this legal complete course you can be find here all the classes has already been scheduled. Just you have to be click upon the subscribe now, and you just be use the code of Ajay. If you will use the code of Ajay, you will get the entire course at the very nominal price of 4619. So here in this particular complete course, your all the classes, the conceptual classes of phase 1 and the conceptual classes of phase 2 will going to be covered. So that's all about the today's session. Thank you very much, guys. If you have any kind of confusion, any kind of question, feel free to be asked in the comment box. Apart from it, if you want to be connected with me, here we have a Telegram group and the Telegram channel. So if you want to be joining the Telegram channel, yes, you can simply be search the Chartered Ajay Thagral, or you can just be scan the barcode of this Telegram channel. Definitely I will help you to be all your doubts, and definitely I will clear your all the doubts. So don't forget to put your all the doubts, and if you have any kind of question related to any of the previous year questions whatsoever we have discussed right now, feel free to be asked in the comment box itself. Now it's a time of completion of the session. So thank you very much. If you like the session, please do like the session as well as share with your friends and the colleague. Don't forget to subscribe the channel. Now we have left with it one of the most important PYQ session, where we will discuss the most important PYQ questions, the memory based PYQ questions related to your 2021 and 2020 and 2021 PYQ. We will going to be covered in the next session, that is on your 5th of November. So if you have not be watched the previous class of PYQ 2024, so go and watch the previous class of 2024 PYQ. What is the exactly PYQ analysis, the memory based questions we have in the previous year of 2024 SEBI Grade A legal exam over here, phase 1 paper number 2. So that's all about the today's class. We will meet in the next class. Till then, take care. Thank you very much. Good night to all of you. Bye bye everyone.